So I have some important news coming out of the Supreme Court's next big two-way case, which deals with ATF overreach. The federal government just had to admit that they expressly lied to the Supreme Court, and they had to admit it. So let's break down what just happened. Now, real quick before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your door every single month. TacPack offers two different tiers. They have the standard, which is about $59, and then the plus box, which is my favorite, which is about $139. But regardless, whatever tier you sign up for, the value of the products that you actually get in your box are way more than the actual cost that you're paying. And right now, TacPack is actually doing something very special for my viewers. If you use code ARMED and it's your first time ordering, you will receive a free $60 tactical box along with your TacPack. So I will leave a link down below to TacPack if you're interested. I will also have it in the pinned comment section, and make sure you sign up using the code ARMED to get that free additional tactical box, which is worth $60. Now, as I mentioned in the intro, in this video, I have some important news coming out of the next big firearms case that is going to be heard in front of the Supreme Court. The Supreme Court recently granted review to the ATF's frames and receivers case, known as Vanderstock versus Garland. The case is now set to be heard and decided by the Supreme Court, and in the next couple weeks on October 8th, the Supreme Court will hear this case. And this is big because we've already recently had the Supreme Court strike down the ATF's bump stock ban just last term, and now they have the frames and receivers case in front of them. And now, very interestingly, just a couple weeks before this hearing, the DOJ got caught lying to the Supreme Court, and they had to file a letter to the Supreme Court admitting that they made a huge mistake. They had to submit a letter correcting that mistake and essentially admit that they lied. Now, to understand what's at stake in this case and why the Supreme Court's hands were forced to have to review this issue, we have to talk about what happened prior in this lawsuit. Originally in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule against unfinished frames and receivers. Now, on review, Judge Reed O'Connor granted a limited preliminary injunction against the ATF, which temporarily prevented the ATF from enforcing their rule against those companies like Tactical Machining and their customers. Now, after the preliminary injunction stage, the plaintiffs then sought to win the entire case, and they asked for Judge O'Connor to grant a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment. That rule was struck down nationwide, but the ATF did not like that, so they filed an appeal up to the Fifth Circuit. The ATF also sought a stay from Judge O'Connor on his judgment. He denied that, and then they also went to the Fifth Circuit, who also denied that stay. That then led the ATF to go to the Supreme Court on an emergency interlocutory basis for the first time. They asked for the Supreme Court to issue an emergency stay which would prevent that nationwide vacatur from going in place. And in a 5-4 decision by the Supreme Court, they agreed to stay the enforcement of that summary judgment, so they sided with the ATF and the federal government. Now, after that Supreme Court 5-4 emergency order, the companies there, 80% Arms, decided to go back down to Judge O'Connor and seek an emergency motion for a new preliminary injunction. And on review, Judge O'Connor agreed, and he issued once again that limited protection. But then the ATF went crying again to the Fifth Circuit. They said that that type of limited preliminary injunction was blocked by what the Supreme Court just said, but the Fifth Circuit denied that. They said no, Judge O'Connor still could put in place a more limited preliminary injunction, which he did, and that led for the second time for the ATF to go crying to the Supreme Court on an emergency basis. And for the second time, the Supreme Court sided with the ATF, so the Supreme Court essentially prevented any positive, even temporary form of relief in this case. Now, the Fifth Circuit recently did rule on this issue. They issued a merits decision, and they agreed with Judge O'Connor that the ATF engaged in overreach. But of course, the ATF did not like that because they still lost at the Fifth Circuit level, so that left them in a hard position, and the ATF decided to go immediately to the Supreme Court. And that was a risk because you had the ATF seeking review from the Supreme Court on the final merits of whether or not their new rule was in fact valid or not. And the Supreme Court recently had already granted review to another case, which was the Cargill bump stock case. And so at that time, I think the ATF was hoping that there would be a long line of cases by the time this was reviewed that would essentially uphold their agency overreach. But as you all know, the Supreme Court granted review to the Cargill case, and last term, they struck down the ATF's bump stock rule. And the Supreme Court here did decide to grant review to the Vanderstock frames and receivers case, and now it is set to be heard and argued in front of the Supreme Court in just 2 weeks on October 8th. Now, interestingly, in their briefs, the ATF makes a ton of technical and mechanical arguments for why some of their prior guidance on this issue was valid, that they were not engaging in contradictory statements, because as a lot of you guys are aware, the ATF has issued guidance letters on these types of kits, on these types of issues, and they have decided multiple times in 2017 and 2022 and other time periods that these types of unfinished frames and receivers are actually not firearms. And it wasn't until the ATF issued this rule on unfinished frames and receivers that suddenly they said these parts kits and these unfinished types of items are in fact firearms. And so in their briefs, the ATF and the DOJ are making technical and mechanical arguments. And what just happened is they got caught lying in some of these briefs. They got caught lying about some of their prior guidance letters and what the actual truth of what they had said prior about these items really was. And so the DOJ had to submit a letter to the Supreme Court admitting that they made huge mistakes, that they potentially were lying, and they had to correct those statements. So the letter from the DOJ to the Supreme Court states that I am writing to correct an incorrect statement in the government's reply brief in this case. The reply brief stated that the Polymer 80 PF 94-0C products ATF reviewed in 2017 and 2022 were different because of distinctions related to the trigger pin hole, trigger mechanism housing pinhole, and material in the front or rear fire control cavity. After the brief was filed, the counsel for Vanderstock, the plaintiffs there, drew our attention to the 2022 ATF classification letter that was not previously cited in the briefs to the Supreme Court, but that were included in the district court's record. After reviewing the 2022 letter and consulting with the ATF, we agreed that the statement in the reply brief was incorrect. Both the 2017 product and the 2022 product lacked a completed, machined, or indexed trigger pin hole and trigger mechanism housing pinhole, and both products had material removed from the front or rear fire control cavities. We apologize for that error. So here the ATF had to admit, and they had to apologize for the statements that they made, that these items that they reviewed in 2017 and 2022 were different. The ATF was trying to argue that their classifications did not contradict each other because the 2017 products that were reviewed and the 2022 products that they reviewed were different. But there was clear evidence in this record that the items were the same, and the ATF came to different conclusions. But they go on to state that they didn't lie, that they didn't make a mistake. They maybe made some mechanical errors. They didn't review the record correctly, but they still claim that the items reviewed in 2017 and 2022 were different enough. They state that the 2017 product did not include any of the locking block rail system or the other items, and it was not designed in a manner that made such parts unnecessary. Indeed, when ATF attempted to insert an ATF-provided Glock locking block into the 2017 product, the product was incapable of accepting it and actually broke when the ATF tried to install it, which is interesting because that also contradicts a lot of the statements that the ATF makes in their brief, that all of these products are so simple to do, they are so simple to modify, and they can be done in 30 minutes, but allegedly the experts, the quote-unquote experts in the ATF, broke something when they were trying to do this when it came to the 2017 products. But they argue that the additional mechanisms that were added into the 2022 product for Polymer 80 made the system potentially easier and made it different enough to where they were not lying in their briefs. The DOJ goes on to state to the Supreme Court that, again, we regret the inaccurate statements in our brief. I would appreciate it if you would circulate this letter to the members of the court. So you may be asking, why is this important? Well, we are 2 weeks out from the Supreme Court hearing this Vanderstock case, and the ATF and the DOJ had to admit that a lot of the mechanical arguments that they made in their brief to the Supreme Court were simply incorrect. And this goes to a long line of clear back and forth from the ATF in their guidance letters, and the ATF trying to say that these items are so different from what they said did not fall under the classification of a frame receiver back in 2017 and prior. The ATF has a long track record of guidance letters and guidance saying that these items are not covered by the statutory text, and then suddenly through this rule they say, oh no, we've always said that they are covered, these items are different, these are covered. So I wanted to bring this to your guys' attention because it's interesting that the ATF had to admit that they lied in their briefs to the Supreme Court, and they had to correct that and get it circulated to the Supreme Court just weeks out from a hearing in the Vanderstock case. So hopefully you guys found that interesting. If you have any questions, go and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.